Chapter 7. Voidable Contracts. Article 1390. The following contracts are voidable or annullable even though there may have been no damage to the contracting parties. First, those where one of the parties is incapable of giving consent to a contract. Second, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. They are suspendable of ratification. Meaning of voidable contracts. Voidable or annullable are those which possess all the essential requisites of a valid contract, but one of the parties is incapable of giving consent or consent, vitiated by mistake, violence, intimidation, undue influence, or fraud. Binding force of voidable contracts. They are valid and binding between the parties unless annulled by a proper action in court by the injured party. The law of obligation and contract. Article 1391. Once ratified, they become absolutely valid and can no longer be annulled. Kinds of voidable contracts. A contract otherwise legal in object and operation is voidable because of defect caused by either. First, legal incapacity to give consent where one of the parties is incapable of giving consent to the contract. Second, violation of consent where the vitiation is done by mistake, violence, intimidation, undue influence, or fraud. Meaning of annulment. Annulment is a remedy provided by law for reason of public interest for the declaration of the inefficacy of a contract based on a defect or vice in consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. Article 1391. The action for annulment shall be brought within 4 years. In case of intimidation, violence, or undue influence from the time the defect of the consent cases. In case of mistake or fraud, from the time of the discovery of the same. And when the action refers to contracts entered into the minors of other incapacitated. Period for filing action for annulment. The 4-year period for bringing an action for annulment of avoidable contract is reckoned. In case of intimidation, violence, or undue influence from the time the defect of the consentences. First, in cases of intimidation, violence, or undue influence from the time the intimidation, etc. Cases before the time the consent is still being vitiated and therefore the victim cannot be expected to bring an action in court. Second, in case of mistake or fraud from the time it is discovered, this must be so because before the time of discovery, the incorrect party is unaware of the reason which renders the contract voidable and cannot also be expected to bring an action in court. Furthermore, the quality party shall not be rewarded for successfully hiding the mistake or fraud. Third, in the case of contracts entered in by minors or incapacitated person from the time the guardianships cases an incapacitated person has no capacity to use. Article 1392. Ratification extinguishes the action to annul a voidable contract. Meaning and effect of ratification. First, ratification means that one of voluntarily adopts or approves defective or unauthorized act or contract which, without his subsequent approval or consent, would not be binding on him. It indicates an invitation on the part of the ratifier to be bound to the provision of the contract. Second, ratification cleanses the contract from all its defects from the moment it was constituted The contract thus becomes valid, hence the action to annul is extinguished. The law on obligation and contracts. Article 1393, ratification may be effected expressly or tacitly. It's understood that there is a tacit ratification if with knowledge of the reason which renders the contract voidable and such reason having ceased. The person who has a right to invoke it should execute an act which necessarily implies an intention. 5 has right. Kinds of ratification. They are express words on writing on when the ratification is manifesting, implied, or tacit. Requisite of ratification. First, the requisites for implied ratification are the following. A. There must be knowledge of the reason which renders the contract voidable. B. Such reason must have ceased. C. The injured party must have executed an act which necessarily implies an intention to waive his right. Examples. First is a minor should has land to be upon reaching the age of majority as with full knowledge of his right in the premises instead of repudiating the contract. In this case, there is a tacit ratification by S. Second, in an action for annulment of a contract of sale is alleged that the sale was executed by him through the threat and invitation of B. It's a part, however, that S deposit the check for the purchase price and withdrew the money from the time to time. The contract then ratified. The requisite for the express ratification are the same as those for implied ratification except that the former is effected expressly. Article 1394. Ratification may be effected by the guardian of the incapacitated person who may ratify. First, a contract entered into by an incapacitated person verified by may the guardian or B the injured party himself provided he is already capacitated. Article 1395. Ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. Conformity of guilty party to ratification not required. Ratification is unilateral act by which a party waives the defect in his consent. The consent of the guilty party is not required. Otherwise, he can conveniently disregard his contract by the simple expedient of refusing to give his conformity. Article 1396. Ratification cleanses the contract from all its defect from the moment it was constituted. Article 1397. The action for the annulment of contract may be instituted by all who are thereby obliged, principally or subsidiarily. However, persons who are culpable cannot allege the incapacity of those whom they contracted nor can thus be extorted, intimidation, violence, or undue influence or implied fraud or coerced mistaking their action upon the clause of the contract. Article 1398. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of contract, with their fruits and the price with its interest expect in cases provided by law. An obligation to render service, the value thereof shall be the basis of damages. Duty of manual restitution upon annulment. First, if the contract is annulled, the parties as a general rule must restore to each other the subject matter of the contract with its fruit, and B. the price thereof with the legal interest. Second, in person obligation, where the service had already been rendered, the value thereof with the corresponding interest is the basis for damages, recoverable from the party benefited by the service. Article 1399. When the defect of the contract consent in the incapacity of one of the parties incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. Restitution by incapacitated person. This provision is an exception to the general rule of manual restitution and under the preceding article. The incapacitated person is obliged to make restitution only the extent that he was benefited by the thing or price received by him. It results, therefore, that he was not benefited. He is not obligated to restore what he had received, but the other contracting party is still bound to return what he had received, whether he was not benefited or not. An expectation to the rule of manual restitution is also provided in Article 1.27. Article 1400. Whenever the person obligated by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss with interest from the same date. Effect of loss of the thing to be returned. First, if the thing to be returned is lost without the fault of the person obligated to make restitution, there is no more obligation to return such thing. But in such a case, the other cannot be compelled to restore what is virtue of the degree of annulment he is bound to return. Second, if it lost through his fault, his obligation is not extinguished but is converted into an indemnity for damages consisting of the value of the thing at the time of the loss with interest from the same date and the fruits received from the time the thing was given to him to the time of its loss. Example, it showed his plow and carabao to be on the petition of S. The contract was annulled by the court, but the carabao dead in the possession of B through his fault. Under Article 1400, B must pay the value of the carabao at the time of its death, with the interest from the same date. If the carabao had given birth, the young must also be delivered as the fruit of the said animal. Article 1401. The action for annulment of contract shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has right to institute the proceeding. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action, unless said loss took place through the fraud or fault of the plaintiff. Extinguishment of action for annulment. First, if the person who has right to institute an action for annulment will not be able to restore the thing which he may be obligated to return in case the contract is annulled because such thing is lost through his fraud or fault. His right to have a contract annulled is extinguished if the loss is not due to his fault or fraud. Article 1402 applies. Action for annulment shall be extinguished only if the loss is through the fault or fraud of the plaintiff. Again, under the second paragraph, the right of action is based upon the incapacity of any one of the contracting parties. Whether the right of action is based upon incapacity or not, the rule is the same. Article 1402. As long as one of the contracting parties does not restore what in virtue of the degree of annulment he is bound to return, the other cannot be compelled to comply with what is incumbent upon him. Effect where a party cannot restore what he is bound to return. When a contract is annulled, a reciprocal obligation of restitution is created. The return by one party of what he is obligated to restore by the degree of annulment may be regarded as a condition to the full payment by the other of what is incumbent upon him. There will be no annulment if the party cannot restore what he is bound to return. This is true even if the loss is due to fortuitous event.
Ano saya Cabusog mo to, boss?